भाई तू काय को सोमनाथ बन के उसको परेशान कर रही है, मुझे ये बता दे। भाई तू काय को सोमनाथ बन के उसको।
Yeah, hi. Am I audible and visible?
Yes, sir. Good afternoon. You're audible and visible.
Yeah, hi.
With your permission, sir, I would like to start.
Sure.
Good afternoon, everybody. On behalf of the Amicus Curiae team, I welcome you to the one-day workshop on mooting skills. We have Mr. Saunak Rajguru, sir, Senior Associate JSA, joining us today. Before moving ahead, I would like to reiterate the general guidelines of the workshop for today. Please try to keep your videos on during the session. Keep yourself muted during the session. You can unmute and can ask questions to sir during the question and answer round. If sir allows you to ask the question in between, you can do so. However, it's up to his discretion. Mooting is a rigorous legal simulation where aspiring lawyers like us engage in mock court proceedings, owning their advocacy skills in legal reasoning while presenting arguments on complex cases. And the Amicus Curiae welcomes you to have a deeper and more profound knowledge of the skills of mooting. The Amicus Curiae is the brainchild of several legal luminaries and eminent personalities across the country and the globe. The Amicus Curiae is a dream online platform which aims at proliferating legal knowledge and providing an ingenuous understanding with cognizance of various fields of law to make sure that legal knowledge and experience penetrates to every nook and corner of the ever-growing legal fraternity. Through ambitious and studious legal brains across the country, the amicus curiae aims at providing valuable contribution to contemporary legal issues, along with development in the omnipresent field of law to the masses. We are also registered under the Indian Partnership Act 1932 and Ministry of MSME, Government of India, and are also an ISO 9001 to 2015 organization. The Amicus Curiae is presently the 8th largest legal website in India. We are connected to more than 20,000 law students from across 80 plus law schools in the country. With us, we have Mr. Saunak Rajguru, sir, who is actively involved in the disputes practice at JSA, with primary focus in the infrastructure and regulatory litigation, which includes energy, power and natural resources, environment, public procurement, civil aviation, engineering, procurement and construction, public-private partnerships, etc. His practice focuses on drafting of petitions, appeals, rejoinders, statements of claims, applications, etc., and representing the clients across practice areas before various fora, being the Supreme Court of India, different high courts, Electricity Commission, Appellate Tribunal for Electricity, sector-specific bodies or authorities, arbitral tribunals, etc. He has been involved in several advisories and legal opinions concerning regulatory issues pertaining to force majeure, change in law, end use of coal by power plants, renewable energy certificates and their trading, renewable power purchases, obligations, etc. He has critically analyzed the issues arising out of the policies issued by different statutory authorities with respect to the practice areas. Sir has been a Bar Council of India Trust scholar with a specialization in constitutional and administrative laws. He has graduated from KIIT School of Law, Bhubaneswar in 2019 and has been associated with the firm since July of the same year. So thank you so much for taking out time from your busy schedule to join us here today. I wish everybody a good and informative session. Over to you, sir.
Yeah, thank you so much, Ms. Bhattacharya, for your introduction, and also thank you for each one of you, in fact, to join on a Saturday afternoon. I can understand it's a post-lunch session, so I'll try my best to be, as engaging as possible, and we'll also keep it more and more interactive, so that we open the floor for discussion. I feel, considering that we have only about an hour to discuss something with respect to the nuances of mooting. What I would suggest is, whenever you have a question at any stage, feel free to just unmute yourself, stop me in between and ask that question so that I can answer it right away. Because the entire purpose of this session is to majorly address your general queries regarding mooting. Having said that, I'm told that basically most of you are participating in some upcoming moot court competition, and so as a matter of fairness, I would request all of you to refrain from asking me any questions that would basically lead to answering anything on the merits of the proposition, which is neither fair nor we should be engaging in that kind of discussion. Barring those, I am opening the floor for any form of questions at any stage. So unless there are any very, very basic preliminary questions that you want me to cover during my session, I can start for the time being. And if you feel that I should stop anywhere, or I should go slow, or I should explain something with much more details or examples, then please feel free to let me know and stop me any moment. I would be very, very happy to address all those aspects. So, okay. What I feel is, considering that most of you are already participating in a moot court competition, so I'm assuming that most of you are aware of, the basic nuances as to how to form a team, what constitutes a proper team, what are the qualities of each and every individual forming part of the team, what should be the common goal of the team, etc. So, leaving aside the aspect as to how to form a team and what should be the important constituents of a team and what should be the roles, etc. I'm straight away moving forward, and today I'll be covering at least 4 aspects. One is how to basically interpret a proposition. Proposition can mean a fact sheet or a statement of case or whatsoever you may call it. The fact is that it's a set of facts that are given to parties who are basically there to act upon it, frame issues, frame arguments, and ultimately persuade the bench before whom they are going to appear. So that is very, very important. It's a key set of documents because those are the very basic facts that you should be aware of. You should also be aware of what facts can lead to what issues. Therefore, as second limb of today's session, I'll be covering uh, the aspect as to how to exactly frame issues out of a given set of facts. Thirdly, I'll be dealing with how exactly to take things forward in the way of research and in the way of argumentation. That would basically mean memorial drafting, because part of memorial drafting includes the research, which gets converted into an effective draft, and how to have your first drafts followed by multiple drafts and how to finalize your drafts is all that we'll cover in the third portion of today's session. And finally, I'll be dealing with the oral advocacy aspects, where basically, how to exactly answer questions falling from the judge, or let's say you have faced an issue where you are not aware about a particular question as to how to deal with that situation, or to generic principles that should be ideally followed for any speaker to succeed in moots, is something that I'll be discussing at the fag end. In between, if you have any other thing that you'd like to deal like me to deal with, then just tell me right now so that I can also cover that. Or if you feel that in between you should while we are talking about something, and if you feel that you need more elaboration, let me know that as well, so that I can cover it appropriately. So unless there is any preliminary questions, should I start? Ms. Bhattacharya, you can also confirm in case someone is also dropping something in the chat box, because I won't be able to have a look at it. Also, excuse me for a very poor throat today. I'll try my best to speak for as long as possible, but just ignore the interruptions that may happen to do. Yeah. Yes, I think someone is raising the hand.
Yes.
Yes.
Hajirath, you may unmute yourself and ask.
Yeah, I feel, just don't raise your hands. Just feel free to step in any moment, because we might ignore someone raising the hand or leaving something on the chat box. Let's make it as interactive as possible. Yes, go ahead, Acha.
Yes, sir. I just wanted to add to your point, saying that it would be much more useful that if we could discuss a point, saying that how to interpret that particular statute or particular law which is relating to the issue, because as a second year student, we find it much more difficult to do that. So I think it will be much more useful if we understood how to use it in issues and how to argue with the same.
Yeah, sure.
Thank
I
you, sir.
think then what I'll do is I'll cover both statutory interpretation and also contractual interpretations, because I feel that would cover the entire ambit. So I'll deal with both, definitely.
Thank you, sir.
Yeah. Anything else? All right. So let me start, so that in case you have anything in between, feel free to jump in. So first of all, dealing with the proposition. So just to give you a brief background as to what happens pre-proposition, as I said, that there's a formation of the team, you need to have a common goal, etc., etc. But even I'm assuming most of you have your proposition in hand by now. Otherwise, I would have also suggested what should be an ideal approach prior to a proposition is released. When, let's say, you have a moot court finalized that you are going to participate, but the proposition is yet to be released. There are some other strategies that can be followed even at that stage. But I'm skipping that for the minute, considering that you already have the proposition in hand. So once you have your proposition in hand, I feel that the first thing that you need to do is write down the facts at least 5 or 6 times. Write the proposition as it is. And because the moment you write it, you'll try and see the loopholes in it. You will try and identify certain aspects where you might as well require certain set of facts to be dealt with in greater detail. And you will also need to understand that some facts are to be emphasized a lot, whereas there will be certain facts which are more or less supportive facts, or something that is going to help you build certain arguments, and basically we call it like fill in the gaps kind of facts. So the first approach is to write your facts as much as possible, read them every day at least twice or thrice, and at the same time, as a matter of practice, take a white sheet of paper and prepare a box. On the left side of the box, you should have the undisputed set of facts. And on the right side of the paper, you should have the disputed set of facts. Now, what I mean by this is, now every proposition will have certain figures, certain data, certain ecological aspects, or let's say commercial aspects, or any form of a figure or any sentence that you think that cannot be disputed or something that has to be accepted by both parties will obviously by its very nature mean an undisputed set of fact. So keep that on one side of the paper, and on the other side of the paper keep all the disputed set of facts. Now, just to give you some examples of disputed and undisputed set of facts. Now, let's say disputed set of fact is, let's take a scenario of a husband and wife being there in a room in a night. There is a watchman in the house. On the next morning, the wife is found dead in a pool of blood. Now, the allegation is, let's say, on the husband. Now, what are the eventualities? Let's say the proposition says that the husband was found to be seen by the watchman with a knife, holding in the morning or in the night whatsoever. Let's say there is a statement like that. Now, obviously, that is a statement that you are bound to dispute. Because if you are representing the husband, you are bound to dispute the fact that the husband has committed the crime or had to do something whatsoever to the crime. Therefore, facts like these are definitely forming part of a category which will be in the disputed set of facts. So any allegations in commercial nature, contractual nature, any breach, any allegation of breach, etc., will all form part of disputed set of facts. And your undisputed set of facts will be like some measurements, some data, some the area of a particular land or certain milliliter of a particular poison. Let's say there is a set of facts which involves certain poison to be infused, and let's say the millimeter is given. So various such things are forming part of your undisputed set of facts. Now, before jumping into the disputed set of facts, let me just explain as to how the undisputed set of facts play a very, very important role. Now, I'll give you a very simple example for that. So, in one of my moots, I think back in 2016 or 17, I was in the finals of a criminal law moot court competition. And in that moot court competition, a question was involving regarding the probability of the husband giving something to the wife through an injection, a chemical called epinephrine. Now, the allegation was therefore that the husband has killed the wife by giving or by injecting epinephrine into the wife's body. Now, I was for the defense counsel and I was basically for the husband, therefore. And my case was that obviously the husband has not committed the crime. So, there was this fact mentioned in my proposition that the quantity of the epinephrine was 250 milliliter, which has been alleged to have been infused or injected into the body of the deceased. Now, in that situation, I did a research as to whether 250 milliliter is enough to cause death of a human being. And for that, I obviously did not merely research, and when I come to a research segment, I'll explain how and what should be a sources of research. But I obviously did not research on any mere article, but I referred to certain scientific reports authorized by duly signed doctors and verified by certain government agencies, also the narcotics bureaus and several other, different ways to ascertain or rather give creditworthiness to a report or an article. I refer to few of those documents to prove that 250 milliliter is not sufficient to cause the death of a human being. And that argument at that stage, the judge kind of intervened into the proceedings and said that, counsel, that was an excellent argument and you're definitely winning the round. So I had just started my arguments and I was hardly 8 minutes into my submissions as the first counsel for defense when the judge already declared me or kind of declared me as a winner. So you never know what kind of things, is going to help you and at what stage. Because sometimes it's that extra bit of research, it's that extra bit of focus, it's that key factor that you bring in on table is what matters. So therefore, have absolute focus on small things such as these undisputed set of facts. Because often I see when I judge several moot courts these days, I notice that students are missing out on observing and making use of these undisputed facts. Because you feel that, let's say, it mentions that India is a socio-economic democratic country. And then, let's say, there is a debate or rather a question is revolving around certain constitutional principles. You ignoring that phrase might lead to a situation where you'll not be able to appreciate the exact constitutional issues involved. maybe an issue is involved regarding economics, and you are missing out on the very fact that the foundation of India's constitution is based on a socio-economic democratic setup. So these are the kind of examples or things that you can use, because had I been at your place, I would have definitely used that to my benefit, saying that it's a bounded duty of the state to also ensure, that commercial and accounting principles or economic principles are upheld, considering that India is a socio-economic state. So therefore, I think, these are the kind of things. So these are only examples that I'm giving. I've done Stetson, where in international environmental law perspective, you are required to get into exact number of figures of how much, how much chemical can actually pollute an ocean, and if yes, to what extent. Further, what will be the exact implication on certain turtles living beneath the sea, and how it will affect their growth, or trajectory of movement, or various such aspects. So these are things of focus, and you cannot miss it. So my first suggestion to you is focus on details. uh, be detail centric, and your approach needs to be, uh, you rather simply put, you cannot ignore any word of the proposition, if I may just put it that way. I think that would just summarize what I'm trying to tell all of you. Secondly, now once you have some clarity of undisputed set of facts, you'll then ask me, how do you use it? Now for that, let me first explain what to do with disputed set of facts. Now, just hear me patiently for a minute, because disputed set of facts will also take you to issues and framing of issues. And let me explain how. So once you identify all disputed set of facts, you will automatically will be able to convert them into certain questions. Now, every assertion in a fact sheet can be converted into a question if it is disputed in nature. Has the husband killed the wife? Is one question in that example. Has the watchman killed the wife? Is another question in that example. Has the wife committed suicide? Is another example. And effectively, is there any chance for an outsider to come into the house, break open, and kill the wife? Is another example. Now, your one disputed set of fact is taking you to 4 questions. So effectively, then you need to understand that what should be my issue. Issue should be that who has killed the wife, right? And I'm just framing it in a very, very generic sense for you to just understand and take these as matter of examples and not as matter of principles of practice, because this would differ from fact to fact and this would differ from case to case. Now, all that I'm trying to say is your disputed set of facts, let's say you're able to frame 70 disputed set of facts. Those 70 disputed set of facts might lead you to frame about like 15 or 20 questions, which can be either a question of law or a question of fact. Then if you see that you will be able to again deduce a final set of issues by combining certain of those questions. So let's say out of those 20 questions left, you'll be able to combine 3 or 4 to form one issue. And effectively, you will have your final set of 4 or 5 issues, which are nothing but questions of facts or questions of law, depending on which forum are you arguing. For example, in SLP, you should not ideally raise questions of fact, and you should stick to substantial questions of law. So therefore, the emphasis why I was putting on the disputed set of facts in the proposition is because that will lead you to frame a question. Sometimes smooth propositions do frame the questions in themselves, but sometimes they also leave an option for the students to add questions to it. Sometimes they make it exhaustive, but be that as it may, it's a general advice for you to focus on the disputed set of facts to understand your issues better. So even when issues are already framed, you should ideally refer it back as to what were the total disputed set of facts regarding this issue, because then that will also help you frame your arguments accordingly. So therefore, I would say that once you have your disputed set of facts, you get your issues at hand. I hope that process was made simpler for you to understand. So once you now have a set of issues, let's say you have 5 issues. Now, obviously, we go into the next aspect, which is the research. Now, for research, there are several ways. Research is not merely searching something on the net or searching something from the book and applying it or having it per se the way it's mentioned in some judgment just apply to your set of facts. That's not how it should be approached. First thing first, you need to first read the entire Bare Act. Now, let's say your proposition deals with intellectual property law, let's say to be specific, Copyright Act, or let's say it deals with energy laws, let's say Electricity Act, or let's say it deals with the Constitution. Now, my advice to all of you would be, if not the entire act, at least read substantial portion of it in entirety first, because reading a, a statute right from its statement and objects or the purpose that it needs to serve, the legislative intent is key. And someone was asking me how to exactly, I think Hajrat was asking me how exactly we should interpret a statute or a contract. Before getting into the contract, now for statutory interpretation, the most important aspect is to understand the legislative intent. Now, how do you understand the legislative intent? You see the parliamentary debates for which a provision was enacted or a statute was enacted. You then see what statement of objects and reasoning of that particular statute capture. Because ideally, a statement of objects and reasonings capture the entire intent behind coming out with that legislation. Thirdly, focus on a draft piece of legislation. Sometimes, or rather most of the times, the parliament comes out with some certain drafts which are obviously produced then before the parliament in both the before the legislature, before Lok Sabha and then Rajya Sabha. At that stage, lot of suggestions are being given to make it better or to make it more cohesive or and also consistent with the other set of laws. At that time, read those notes of the parliamentary sessions. Those are publicly available. You can always read them, because that will make you understand that what is the problem with the law. Was there any concerns regarding the interpretation? Was there any aspect that should have been dealt better? And finally, what were the changes made from the draft to the final implemented piece of legislation? And that would show you a difference as to what are those things that you are thinking should have had happened but has not happened. For example, now let's say a piece of legislation is there with 10 sections. Let's say the draft had 11 sections. Now, while understanding those 10 sections the way they are implemented, you are basically perplexed with the question that is there any ambiguity, or let's say while interpreting section 10, you are getting two meanings out of it. Now, let's say one of those meanings earlier was addressed in that section 11, which used to be there in that draft, but eventually removed. That means that second opinion or the second thought or the second view or the second interpretation that you were getting out of section 10, which earlier was there in section 11, the removal of it means that the parliament or the legislature did not mean that particular aspect. That means that interpretation is the wrong interpretation. Sometimes you get the benefit of these kind of research. I have got a benefit of it a lot, both in my mooting journey and also here in practice for the last 4.5 years. So now, therefore, what I'm trying to only emphasize on is understand the legislative intent, be it through any source. If you're doing an international moot, you need to focus on the Trevor preparatories, what we call it, which are nothing but same as like the pre-documents to a legislation in India. If you are doing a national moot or a domestic moot based on domestic laws, focus on the background of the statute. Now, once you are done that, you will at least understand what was the intent behind the law to be framed. I have one simple example in this context because I'm working in the regulatory space and I deal with the power on a daily basis. So what happens is, for example, the Electricity Act came in 2003. Earlier, prior to Electricity Act, the government was the major stakeholder so as to frame any regulatory laws regarding the sector. Let's say the government was deciding how much tariff, or which is nothing but the rate of power purchase, should be paid by a distribution company to a generating company, and several other such aspects, which was making the system more or less non-transparent, and the independent decision making was not there as much. Whereas the Electricity Act comes in and creates a new independent commission, gives all the powers of a legislator, also an adjudicating body, and also a regulating body, creates that body as a first court of instance, and distances the government from all forms of regulatory affairs. Therefore, if you see the object and purpose of Electricity Act and then interpret a question involving Electricity Act, you'll be better able to appreciate situations, and interpretations will be in that regard as to whether government should interfere into regulatory affairs or not. So this is one example that I could immediately think of as to how alignment of objects and reasons can be very, very important to interpret a statute. The other thing of research is, you know, is to focus and go in the old school mode. Now, what I mean by old school mode is basically that focus on the text, focus on the commentaries, start reading the commentaries from the time that the law was enacted until the time the commentary is published. Now, just to give you an example, let's say some statute was enacted in 1960 and the commentary deals with all interpretations, judgments starting 1960, and let's say the commentary was published in the year 2012, and maybe your library has an outdated version of the commentary, let's say 2012. At least the benefit that you'll get by reading that commentary is you will understand how the law has developed, how the judgments have dealt with issues concerning that particular area of law over the last 60, 70 years. You will see the whole changing narrative. For example, a simpler example is Article 21 of the Constitution, the shortest but the widest meaning based article in the Constitution. If you see the interpretation over the years, it has been ever evolving. And therefore, if you read the judgments right from the beginning, and then slowly into 1980s, 1990s, with all the MC Mehta coming in, with all other forms of judgments coming in, interpreting Article 21, until date, when even plants and animals are being forming part of Article 21 until right to lives matter. And finally, how even the genuine privacy has traveled, right? Earlier it was held to be not forming part of 21, and now with the Constitution bench coming in with the right to privacy matters, and then the Aadhaar, it's very clearly laid down and emphatically laid down that it does form part of right to life. Therefore, the journey of a law will be clear if you actually read a commentary in detail. And that commentary will actually therefore help you understand maybe what laws or what judgment should be referred, what has been subsequently overruled, because you should never quote an overruled judgment. Plus, knowing that will also help you remember certain set of facts of certain judgments. You will also understand what is the landmark judgment concerning an issue, because sometimes it happens when you get into, let's say, every sphere of law has some landmark judgment associated with it, provided that issue obviously reach Supreme Court and then the law is settled. So when you are dealing with that kind of a proposition which might have a landmark issue for it, and then as part of your oral advocacy you're not referring to that landmark judgment, also shows that you do not know the most important judgment concerning that area of law. And your chances of knowing that landmark judgment increases if you actually read a commentary, because the commentary at least 50 times would have referred to that one judgment while dealing with other judgments. Because, for example, let's say in 1970 on a particular issue, there is a Constitution bench judgment of 5 judges. Now then subsequently, whatever judgments would come, the commentary would then see or kind of analyze those judgments in light of that Constitution bench judgment which has already been passed. For the reason that obviously a lower judge bench judgment will not supersede a Constitution bench judgment. And therefore, in that context, you will also be able to appreciate that you will get some judgments which has higher bench strength, only to improve your case. Let's say on a point of law, you have conflicting judgments of Supreme Court. So what would come to your rescue is which judgment has a higher bench strength. If a judgment is of 3 judges versus a judgment is of 2 judges, the 3 judges judgment is binding, right? Or will have higher, at least precedent value so far as that matter is concerned. So therefore, especially Constitution bench matters comes in, that would mean that any other judgment will obviously not stand in its way in case it's conflicting. So therefore, you need to really understand these aspects, and reading a commentary will just give you that entire narrative. Having said that, commentary's downside is it may not be up to date. And for that is therefore your next leg of research. That is, at this stage, you can come and rely on your online sources. Now, for what do these online sources consist of? Although I will not comment much on the kind of sources that you should be referring to, but the authorized, licensed, service-based online sources are the better ones versus those which are available freely in the public domain. For the simple reason that those freely available public domain, access systems can easily be hacked, can easily be edited. Even the Allahabad High Court, in one of its detailed reporting judgments, has criticized one of such freely licensed, access body to have, kind of basically lawyers were referring to judgments by editing them, and that is what was criticized heavily by a Allahabad High Court judgment. And ideally, you should try and avoid that. No judge in the moot court will also appreciate judgments not being given from licensed sources. So focus on them, and then because that would basically give you the up-to-date judgments, you will have the judgments which will be of 2023 itself. Uh, Basically, the whole narrative would then get covered, right? So because you now know the law starting 1960 to 2012, and followed by that, whatever is left, your online resources will fill that gap. Now, therefore, this is how you should research. This is how you should basically then parallelly start drafting. Now, what do I mean by that is, let's say you get really good sentences from judgments. My way of drafting was always relying on certain good sentences from the judgments, not copying it, but at least to form my base, I was using those judgments and then develop a rationale to it and then apply the facts to it. That is what will give you your arguments. So let's say on an issue of blowing hot and cold, or let's say on approbation, reprobation, or let's say we are dealing with a contract where a party is kind of let's say there is an issue where I am a contracting party and let's say Ms. Bhattacharya is another contracting party, and I as a contracting party is taking benefit of what is to my favor, but I am also reneging away from my obligations for what part is not in my favor. So that is a classic case of hot and cold, or blowing hot and cold, which is nothing but approbation and reprobation. Now, in that situation, you'll get some judgments which will also very clearly lay down certain, very nice sentences for framing these arguments, and then you form base form those sentences as base, apply the principle, then refer to the judgment, and finally apply the set of facts. That is how you frame your arguments. And while framing arguments, so I'm slowly now coming to the memorial aspect of it. While framing arguments, I think your focus needs to be on Iraq. Now, I'll go a bit slow in explaining Iraq. So, what Iraq is basically, I stands for issue, R stands for rule, A stands for assertion or analogy, or your analytical skills will come in A. It's basically assertion or analogy, and finally C is conclusion. Now, therefore, in Iraq, in I you will basically frame the issue. Now, issue is nothing but your question of law or question of fact. R is something that basically is the rule. Now, what is rule? Rule can form nothing but your statute, your notifications, anything that can be a source of law, judgments, even circulars, orders, notifications, bylaws, anything for that matter is all forming part of rule, followed by an analysis. And that analysis is something that you need to be critical about. You need to apply your facts there to the law. You need to deal with the judgment. You need to also elaborate as to how the judgment that you're referring to is helping to your set of facts. And finally, the conclusion. That means you'll conclude it. After asserting a particular argument, you will conclude as to what you effectively meant by that. So, I would suggest that your memorials should have Iraq everywhere. And by everywhere, I mean it should be there in every para, it should be there in every sub issue, and it should also be there in effectively an entire issue. So, what I mean by this is, ideally, your memorial should have issues, then you should have sub issues, then you'd have sub issues, then you should ideally follow IRAC at each stage. Now, having said that, let me also give you insight as to how exactly you can frame these issues and sub issues or sub issues. Now, let's say you have an Article 32 petition. Sorry, Ms. Bhattacharya, if you can just confirm, I hope that students are not having a 32 petition to deal with in the upcoming moot court competition. Will you be aware about it?
I am not aware of that.
Anyone, any of the participants, can you just quickly confirm if it's not 32?
We have one. We have a Lucas Standa issue.
Okay, then let me not deal with this. Let me give you a different example. Let's say, so is Article 136 involved?
Yes.
Is Article 136 involved by any chance? SLP? Anyone? No, anyway, I'm since I'm not very sure, let me not get into any example as such, but what I was only trying to explain was that every time you frame an issue, try forming a sub issue and then try forming a sub issue to it. Now, that is what will help you effectively to frame a proper argument. Or even on that issue of locus or maintainability, your sub issue should be as to why you think it's maintainable. What are the grounds for maintainability can be different sub issues. So that is how you can frame your issues, sub issues, and then sub issues, and deal with a sub issue, right? So all these are aspects of memorial drafting, and unless there is any specific question, considering that we are approaching towards the last 10-15 minutes of the session, let me now come to the issue of, or rather the aspect of oral advocacy. Now, once you are done with your memorial, you have submitted that. Obviously, I feel that at least in my experience, I used to start my oral advocacy practice long back. It was not only at that phase when I'm submitted my memorial and I'm left with very few days for the competition. If you start at that stage, you will panic. I'm for sure, given a fact that most of you are mooting maybe for the first time or second time, or at least twice, or the third time. I feel that the more you practice, the better you get at it, and therefore I feel that it should start right from today if you haven't already started for the competition, or for any of your future competitions. It should ideally start 3 months prior or 2 months prior to the rounds. Your oral preparation should start. Now, how to approach it is, if I deal with it. So let me just share with you my experience of how I used to do it, because I don't think there can be any general applicability of a norm per se to prepare for orals, because everyone will have a different way to approach it. So what I used to do, I used to first prepare my final speech. I used to prepare a speech that I was going to deliver in the final round before the final set of judges, because that is something that requires you to speak for at least an hour, can go up, because of the reason that, for example, in my BCI finals in the Bar Council of India moot, when we won that in 2017, I had to argue for over 2 hours 15 minutes, and my co-counsel had argued for over an hour, and the other side argued for about 1 hour, 1.5 hours, and 2 hours, and that lasted for a 5-hour long round. I have never seen that in my life till date, at least. But yeah, that's a possibility. I have definitely argued for over an hour in a lot of moots, but 2 hours was a bit too much that time. Basically, because the judges were absolutely inclined, they were interested, they were engaging, they were asking questions, and that never stopped. Especially in a situation where I really did not have much of a law to support my case, and I was having a case which is absolutely contrary to the law, rather, and we had to prove something based on certain placing reliance on some certain international laws and several other documents. So therefore, to prepare for that, I would suggest that start right from the beginning. Your approach should be that how to tackle with the speech for the final round. The moment you do it, say for example, you have a longish speech ready, it's very easy to then shorten it or curtail it, and then identify or churn out the most important things for the semis, then slightly churn it for the quarters, again churn it absolutely and keep it crisp for the prelims. And for your prelims, your approach should be that let's say on a particular issue, you should have at least two judgments to cite. Every argument that you frame, you should at least have two judgments and one any other authority, such as law commission report or any other ancillary report that you're referring to, or any other source of law that you're referring to. Have a good mix of judgments and such documents. Let's say a report. The way I said, I refer to an epinephrine-based medical report and an examination-based document. Sometimes I used to refer to expert opinions regarding ballistics. While doing constitution, I used to refer to law commission reports. While doing international environmental law, I used to refer to several government agencies reports or the UN reports, or there are several convention-based reports. So it can be a variety of things. Just focus on the fact that you're not referring to anything hearsay. You're not referring to any mere random article available on the internet. You're not referring to newspaper articles. You're not referring to, as I say it, all of it would fall in that category of trash documents. Please do not refer to that. Rather, refer to something that you feel will have some creditworthiness for it to stand in the court of law. How to refer to these documents, which are not really legal per se, like for example scientific documents. Obviously, if you're adducing it as evidence, the Indian Evidence Act recognizes scientific experts and their testimonies as piece of evidence. If you're referring to environmental law definitely gives credence to environmental reports and by technical reports. Every such court would entertain such things. Otherwise, what you can also do is you can get a judgment of Supreme Court, where in the past they would have relied on similar kind of a report. Let's say if you're relying on a law commission report, why don't you take and show to the judge that, look, in the past Supreme Court in several judgments, one of these is this, where Supreme Court has dealt with or rather relied upon law commission reports to render a finding. As a matter of similar practice, I'm also relying on one. So this is how you can actually bring in that extra factor into your speech alongside judgments or quoting provisions, because that is something everyone will do, right? The next thing that I would suggest is, how I went about my speech is that I used to write every detail. I used to write right from good morning till the last aspect, although I never used to refer to my papers, but that is something I always used to write. And I also used to write the exact extract of the judgment. It was always with me. I used to write the exact name of the judge, exact name of the entire case, the citation of the judgment, and the bench strength of the judgment. And then I used to supplement it with a compendium. Now, what is a compendium? Compendium is a compilation of all the legal documents that you are going to place reliance on, which are not on record, which are not forming part of your proposition or any other thing. Let's say you are referring to a judgment, a law commission report, or anything as such, or even a provision of a statute. It's advisable to submit compendiums. And once you have compendiums in place, in a physical mode, try and flag it. Flag it as just write 1, 2, 3, 4, 5. At least I'll tell what I used to do. I used to, in my speech, I used to mention, let's say I mentioned Keshavananda Bharati, I extract it. I have it written in my paper, and I just write 1 against it. And the flag in the compendium, the flag is also numbered as 1. So when I request the bench, I just request them that if your lordships may kindly refer to flag number 1, and I'm referring to the judgment of Kesavananda Bharati. I don't write whole of Kesavananda Bharati in that flag, because then the judge will not be able to find it immediately and you will lose time on that way. Secondly, writing just 1 will again ensure that you're not losing much time in the judges figuring out the documents and opening it. You'll save crucial time. And these are 2 seconds saved in referring to 1 judgment, then 20 other judgments would mean that you're saving a minute of extra arguments. And that is very, very crucial. So these are the kind of tips, that you can actually try and follow to be more and more efficient during your speech. Now, obviously, then comes a situation when, how to deal with questions of the judges, what happens if the judge keeps grilling. So my simple response to that is, number 1, answer all their queries. Do not shy away from a question, be it even if it's asked at any stage of the rounds. Do not shy away from questions, answer it right over there. There may be a situation that you're asked a question that even does not deal with the issue that you're handling, but answer it. You secondly, you cannot be in a situation where you're not aware about an answer. So obviously, I was expecting to receive a question, which I mostly receive during these kind of rounds is what do I do if I do not know an answer to a question. Now, my response is you should not be in that position in the first place. If you are preparing for a moot, you cannot not have an answer for a question. But in case, by any chance, for whatsoever reasons, be it your lack of research or despite knowing everything, something is coming out of the box and you did not know it, only then plead ignorance, but never bluff to court. Do not mislead the court. Never say something that you feel that can antagonize the bench, and focus on responding to the questions. If you do not know an answer, just apologize, or rather, a better approach is if you think that your colleagues may know it. I mean, your teammates can know it. In that situation, what you can at least do is request the bench to come back and answer the question during the rebuttals. At least that will be appreciated that than not answering the question at all. You'll also get some time to do your research by referring to certain books or whatsoever, even in internet research if you are basically in a virtual round, which ideally I would not advise because that's not ethical. At the same time, having said that, your entire focus, as I said, needs to be on answering the questions. Forget your speech if you think that you will not be able to cover this issue, that issue, etc. Does not matter. What matters is how much questions have you answered, if questions were being asked to you. Therefore, I would suggest that let's say you have 15 minutes and your 10 minutes are being taken by answering the questions to the bench. The judge knows that he or she asked a lot of questions, and therefore obviously the candidate is not going to cover the entire speech. So don't make it evident that you're losing out on something. Don't make it evident that oh, so much was left to argue, I didn't argue anything. Do not leave that impression with the judges, because at least the judges who ask questions know that they are not here to just simply hear your speech, but rather they are here to understand how much of law or how much of depth you have in your submissions. Therefore, ideally, at least when I grill, I just kind of convert it into a Q&A session for over 15-20 minutes, and I judge the participant by that nature. So because it depends also on different kind of moods and what the college authorities also sometimes advises. So therefore, I think your focus entirely should be on answering questions. If you get a passive judge, or if you get a judge which is not saying much, they are purely observant, they are not speaking, or they are not reflecting upon what you're saying, in that situation, engage them by referring to fact sheet time and again. Engage them by making an eye contact. Do not lose an eye contact with the judge. That's the most important aspect. Otherwise, he'll not listen anything, he'll fall asleep. And lastly, engage them also by using your compendiums. That's the best way to engage a judge. Ask them to read, obviously in a very polite way, in no manner hurting their feelings or whatsoever. Right. So I think these were certain tips that I had to share today. I feel that I have covered most of it. Obviously, in 1 hour, it couldn't have been covered in much more detail. But if you have any questions, I leave the floor open for the next 5-10 minutes so that we can address the questions and then maybe we can close the session. Yeah, I think someone has raised a hand.
Yes, sir.
Yeah.
So my name is Sanjana. Good afternoon, sir.
Yeah, hi, Sanjay.
Yeah. Sir, actually, I just wanted to know that all the concepts and the rules which you have told regarding mooting, it can be very much possible when it is done in a physical mode. But now, because we are having this competition on virtual mode, I just wanted to know that what other things we should keep in note while we are doing mooting in virtual mode, because as you said that we have to do flagging on the documents on the memorial which we have to submit. There
Yeah.
can be a situation while arguments that we have some extra documents which we just got on the spot and we have to show to the judge.
Yeah.
like how we will present it and what other things we have to keep in mind, especially we are doing moot in the virtual mode. So
Right.
yes, sir.
So two, three things. First is still maintain an eye contact. Try looking at the camera of your screen than looking at the face of the individual as it appears on your screen, because that is how you make an eye contact. That's one. Secondly, try not to read anything, because at least in virtuals, I've seen students trying to deceive the judges by referring to the screen as if they are not really reading. They are opening something in the screen and they're reading, but it's very, very evident. Don't do that. Sometimes people wearing specs and all, it obviously appears that something is right in front of you and you're trying to deceive. Or sometimes even otherwise, the movement of your eyes is very well noticeable, right? So don't do that. Secondly, after that, regarding presentation of documents, that's a very good question. In virtual, I would suggest that focus on compiling all your documents in a soft PDF and bookmark it. And your bookmarkings should be in such a way that they are well numbered, and they if the organizers permit, also share it with the judges so that judges can also have it open in their systems and parallelly see it. And at the same time, someone, maybe a researcher, can also present the document on screen and can screen share it. Having said that, screen sharing multiple documents one after the other is not a good idea. Rather, compile it, and let's say you're referring to 10 different documents. Let's say compile all 10, bookmark all 10. You'll have it all in one simple document after that. It will be a longish document, but it will be very easier to go to the next document because of the bookmarks. So learn the bookmarking. I think bookmarking is something that is going to help you in that. And we have been at least really assisting the courts in a better way since COVID struck us, by way of bookmarking documents and screen sharing while we present our case even in courts. So I feel that that would be a better way to deal with the situation, because then obviously the flagging and the compilations don't work. But what will work definitely is a convenience compilation shared already with the judge's prior hand. Soft copies will do. So yeah, I think that is something you can focus on. Apart from that, I don't think anything is different in the approach to a physical moot or a virtual moot. And I feel that try, because these days physical moots are back in the days. So I would suggest that try and do more and more physical moots as well, because that is where the real experience lies. And you will also get to meet a lot of individuals across nation, or sometimes across different nations, where you will be able to interact with everyone, and that's a better learning sharing experience. Yeah.
Thank you, sir.
Thank you. Anything else? All right. I think we can wait for a minute. Unless there are any further questions, we can close the session, subject to Ms. Bhattacharya having anything to add on that.
It says, as we have for our competition, that we go about our preparation. Excuse me, so we have a question in the chat box.
Yes.
It says, as we have only 1 month for our competition, how do you suggest that we go about our preparation?
Yeah, I think that's the same approach. I don't think the approach changes, even if it's for a month, even if 3 weeks, or sometimes even a week. The approach never changes. I think there's no shortcut to it. The approach that I suggested is something that you'll have to do, especially for drafting and for preparing your oral rounds. Obviously, the research goes hand in hand, and I'm sure you already would have got the proposition well in advance, and you would be in the better situation so far as the first stage that I was explaining, and subsequently your approach can be there to read. So I would rather suggest on focusing more on the judgments to deal with in an effective and efficient manner than going through other resources. Obviously, the commentary along with the judgments should help you even in a month. Yeah. Yes. Anything else? All right. So should we put an end to the session? Is it okay, Ms. Bhattacharya?
I mean, if anybody has questions or suggestions, then they might ask it now. Or, I mean, sir is pretty busy, we know. I think that's it for today, sir.
Yeah. All right.
Sir, thank you so much for being here today. It's an honor, in fact, to extend my heartfelt thanks and acknowledgement to all those who have made this workshop and an invaluable experience. I would take this opportunity to first and foremost extend my gratitude to you, sir. Thank you once again. Your guidance throughout the workshop was quite enlightening and invigorating. Your ability to simplify the complex legal concepts and your patient responses to the questions made the learning process both enjoyable and effective. At the same time, I would also like to express my deepest appreciation to the organizers at the Amicus Curiae team who have put their heart and soul into conceptualizing and executing this workshop. Your dedication to promoting legal education and providing us with platform to enhance our advocacy skills is truly commendable. To the participants, thank you for joining. Your enthusiasm and active participation contributed to a very dynamic session that has enriched our understanding of mooting. As we leave this workshop today, equipped with new skills and insights, let us strive with the spirit of learning and the passion for advocacy. Let us strive to implement what we've learned today over here, not just in courtrooms or mock trials, but in every facet of our lives where critical thinking and persuasive communication are very vital. Once again, my heartfelt gratitude to everybody who have joined, who have contributed in making this workshop a real success. Thank you so much, sir.
Thank you so much, Ms. Bhattacharya, and for everyone to joining in. And thank you for your patient hearing. I'd love to also, be contacted otherwise as well in case you have any queries, barring for the merits of the moot court. Feel free to reach out to me otherwise on my mail or any other forum that you can. And happy learning. Thank you so much.
Thank you so much, sir. Have a good day.